All right, it's time for another edition of Ask Ed Live. That's right, my name is Attorney Edward Littlejohn, and I'm here today to provide you with the probate and estate planning tip of the week. If you're new to the channel or new to the group, please subscribe so that you can be notified every time we publish a new video. Today we're going to be talking about intestate succession and parentage, and kind of how it all works together when a loved one passes away. So the first thing that I want to share with everyone is, what is intestate succession? It's a fancy word that means that somebody died without a will. Okay? So intestate succession means somebody died, they didn't have a will. And so the Ohio Revised Code lays out a process to determine who's supposed to inherit. The first person that they identify who should inherit the estate is a surviving spouse. So somebody's married, they die, surviving spouse inherits everything. If they have children, then it would go surviving spouse. If that person is deceased, then it would go to their children. Now, here's where it gets tricky. If the surviving spouse is not the natural parent of one or more of the children, then the surviving spouse takes and the children take. So it's a little bit, I guess it requires a little bit of analysis. Now, if the surviving spouse is the natural parent of one of the children, but not all of the children, then under the law, the surviving spouse is entitled to a larger amount, but then he or she has to split the remainder of the estate with the children. If there's no surviving spouse, no children, then they go to the parents of the deceased equally. If there's no parents of the deceased, then it looks to see if there's any siblings, okay? And here's where it gets tricky. I want to read the specific language to you under the Revised Code. If there is no spouse, no children, or their lineal descendants, so it's the children or the children's lineal descendants, and no parent surviving, it goes to the brothers or sisters. So from time to time, we get clients whose siblings passed away years ago. Nobody opened up an estate, okay? And now they want to open up an estate. So typically what we have to do is build a family tree. We have to identify if the surviving spouse if is alive, if there were any children, if the children had any lineal descendants, before we go up to the parents. So as you can see, it can turn into a big web. But one of the new things that we've seen is, what happens if someone passes away and they've never legally adopted a child. Under the law, if you are not legally adopted, but you can show that the parent-child relationship has been created, or you can show that parentage has been established by way of the probate court, then you can inherit. We once worked on a case where a brother and sister were not born of the marriage, and so we call that an illegitimate child. And as a result of that, when the father passed away, there was an issue to determine who should inherit. Now, under the eyes of the law, the father would have had to establish parentage, right? He would have had to establish the parent-child relationship with the son and or the daughter in order for them to inherit. And so if the parent-child relationship hasn't been established, then under the law, the child cannot inherit. Now, there are certain exceptions to that rule. One is if you marry the person, so that you marry the child's parent, or if you adopt them, or if you designate them as an heir at law. So there are several exceptions to the rule, but in order to be safe, you need to get a will. And most people need a trust if they're concerned with long-term care costs. So get a will, get a trust. Now, that's critical. Why do I say get a will, get a trust? Because it takes it out of the intestate succession, right? It takes it out of the probate court's realm for them to decide, but rather you identify in a will and you give them a guideline for how you want your assets to be transferred. who you want them to be transferred to, and what they'll actually receive. So if you don't have a will, contact my office for a complimentary needs assessment so that we can help you guys get your affairs in order. And remember, where there's a will, there's a way. And where there's no will, then there's probate.